Basis, I guess. Evan Larmon, can you start your video?
Yes.
Darian Wells, please start your video. And Kathy Smith, start your video. Who's on the phone number ending in 6311? Ms. Smith, can you hear me?
Yes.
Okay. Who's on the phone number 2756311? Is that Mr. Wells? We can't hear you.
Can you hear me now?
Okay, yes. Let me see if it'll let me merge. I don't think it will.
It said, it got me on some screen that says tap to speak.
Yeah, so it's essentially has you here like you're on two separate devices, but I don't know why. It's not letting me merge with your video, so we'll just leave it as that. Okay.
Can you still hear me?
I can still hear you, thank you. Ms.
Oh,
Smith,
okay.
Who is Nicholas Palmer?
My son?
Okay, he's an adult?
Yes.
Okay, is he not present today?
He is. He went to the bathroom because it was taking so long, but he is here.
Okay, and then let's see, who's in the waiting room? Who just joined from the iPhone? Who just joined from the iPhone? Ma'am, what is your name?
Tamika Beam.
Okay, Ms. Smith, Mr. Palmer, Mr. Lermont, and Mr. Wells, and then Ms. Beam. Today is the date that's set for an eviction. This is for non-payment of rent. I'm gonna play a video for you, and the video will go over your rights. It'll also advise you of resources that you may be able to access to help you avoid eviction. We have representatives from legal services present in the courtroom today. You can meet with them if you'd like to discuss them representing you, if eligible. We have an eviction diversion facilitator here at the court, who is currently joining our virtual courtroom as we speak. You can meet with him if you want to discuss any of the potential resources that you can access to assist you during this time. And then lastly, we'll give you your next court date. That's a date set for a hearing. You must appear in person, okay?
Okay.
Okay.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen to the 54A District Court. Please listen. You have a right to retain an attorney to represent you.
Yeah, my whole thing went away. I don't know if nobody can hear me or not.
And you cannot afford. Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Okay, Kathy Smith and Nicholas Palmer.
We're both here.
Your matter is scheduled for a hearing in person at the court August 14th at 3:15.
Okay.
Let's see, did you want to meet with legal services today?
No, just the attorney for the complex.
Miss Wilburn, are you available?
I am, Judge. I just have two more, if I could get the dates for those, and then I'm happy to meet with them.
Okay, yes. Tevin Larmond, your date for hearing in person at the court is gonna be August 14th at 3:15.
Okay.
Did you want to meet with legal services?
No, just with the attorney for the apartment complex.
Okay, hang tight and we'll get you in the meeting room in just a moment. Mr. Wells, your matter is scheduled for hearing August 14th at 3:30.
Okay.
Did you want to meet with legal services?
No, just a complex attorney.
Okay, so hang tight, we'll get you in when she's available. And then, Ms. Beam, who's Wayne Davis?
My boyfriend.
And is he present?
Yes.
Good morning, Your Honor.
Good morning. Your matter is gonna be scheduled for hearing in person at the court, August 14th at 3:30.
August 4th at 3:30.
Do you all want to meet with legal services today or with the eviction diversion facilitator?
Yeah.
Yes.
Okay,
What?
let's see. Ms.
No.
Nagel, can I, excuse me?
No, we don't.
Okay, well then you're all set. We'll see you at your hearing.
Thank you.
You're welcome. Okay, let me put Ms. Wilburn in room 1, and I will put Ms. Smith in room 1 first. All right, sir, your name?
Yes, Dr. Hamilton.
Okay, Mr. Hamilton, today's the date set for a pre-trial. This is an eviction matter. I'm gonna play a video for you. The video will go over your rights. It'll tell you how this matter could potentially be resolved, and it also will go over potential resources that you may be eligible for in order to avoid an eviction. I'll get you your next court date after the video. You also can meet with legal services if you'd like to discuss them representing you for free. And we have an eviction diversion facilitator present today in the virtual courtroom. You can meet with them if you'd like to go over any of the resources to help you during this time, okay?
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Are you all set with Ms. Smith?
I am, Judge. She had a question. She's going to be pulling money from her 401k, but she needs a signed judgment. She's willing to enter into a consent judgment today. I don't know if Your Honor is willing to enter that today.
Yep, that's no problem.
Okay.
Let me get Mr. Hamilton all set. Mr. Hamilton, your matter is going to be scheduled for hearing August 20th at 1:30. You must appear in person for the hearing, okay?
1:30.
Did you want to meet with at 1:30, August 20th?
Okay, sounds good.
Do you want to meet with legal services today or with the eviction diversion facilitator?
I'll speak with the eviction diversion facilitator. Yeah.
I'm sorry, and this should have been August 28th.
It's actually August 28th.
Yes,
Yeah, and that's still 1:30, correct?
at 1:30.
Okay, gotcha.
Okay, Mr. Rosa, can I put Mr. Hamilton in the room with you?
Absolutely, Your Honor. Thank you.
You're welcome. Let me see, room 2. On the record in the matter of the people, I'm sorry, wrong day. On record in the matter of Briarcliff Apartments versus Kathy Smith and Nicholas Palmer. File number is 24-03667. Council, can I have your appearance for the record?
Morning, Judge. Jen Wilburn, P83143 for the plaintiff.
Today's the date that was set for a pre-trial for an eviction proceeding. The matter is scheduled for hearing in person August 14th. However, the parties would like to enter a consent judgment today so that the tenant can access some funds from her 401k. Is that accurate?
That is
Yes.
correct, Your Honor.
Okay, can you put the terms on the record, Ms. Wilburn?
Absolutely. And Ms. Smith, we will need Mr. Palmer for this as well.
Okay.
Hello. Oh, shoot.
Ms. Beam, how can I help you?
Hi, I left the meeting, but I did want to speak with the attorney.
I have Mr. Palmer here. He's here as well.
Let's see, Ms. Snable, can I put Ms. Beam in the room with you?
Yes, Your Honor.
Okay. Let's see, it should just say add you to room 3. Okay, Ms. Smith, it's blurry. I can't see anything on your screen.
Oh.
Okay, counsel, you can proceed.
All right, Your Honor, there's currently an outstanding rental balance, $5,822.49. Court costs in the amount of $230.16 for a grand total of $6,052.65. We are using the writ date that would be given from the next hearing, which takes us out to August 26th. Partial payment will not prevent an order of eviction. It would need to be that amount in full. There's no money judgment at this time. One thing I did not do is go over MCR 4.201J, which I will do now. Ms. Smith, Mr. Palmer, what that means is you do have the right to an attorney. You have the right to a trial. By entering into this, you will be giving up the right to a trial. But since you guys are unrepresented, you would have 3 days to file a motion with the court to have this set aside if you didn't understand something that went on today.
Okay.
Okay.
Okay, so Ms. Smith, understanding that those are your rights, you have the right to be represented by an attorney, and I offered you an opportunity to speak with legal counsel today to do an intake. Are you gonna waive your right to counsel today?
Yes.
Mr. Hamilton, are you waiving your right to counsel? I'm sorry, not Hamilton, this is Mr. Palmer. You're waiving your right to counsel as well?
Yes.
Okay, you also have the right to proceed to trial, and on the video, it indicated that you could demand a jury trial. By entering into this agreement, you would have to give up your right to have any trial, and your right to make any claims or counterclaims against the landlord for conditions of the property. Are you giving up or waiving your right to trial today?
Yes.
Okay. Anybody threatening you to do that?
I'm sorry, what?
Anybody threatening you to give up these rights?
No.
Mr. Palmer? I can't hear his response. I can't hear his response?
No.
Okay, and so lastly, are you both giving Ms. Wilburn permission to sign a consent judgment with the terms stated here today on your behalf so that she can file it with the court today and I can sign it? That will expedite that signature process.
Yes.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood any of the rights that we advised you of, you can return to the court, request to have this judgment set aside. You would have to explain to the court how you misunderstood your rights. Any additional matters for today's record, counsel?
Nothing for me, Judge. Thank you.
Okay, you're all set. Thank you, Ms. Smith and Mr. Palmer.
So we can leave?
You're free to go.
Thank you.
You're welcome. And Ms. Cox, I can put Mr. Larmond in the room with you now.
Should I
I'm
just go
in the
back to my
room, but
breakout room?
Yes, you just go back to room 1.
Okay,
Thank
thank
you.
you.
Okay, thank you, Mr. Rosa. Let's see.
You're welcome, Your Honor.
did they put me in the room, Your Honor, for the lady?
No, because you all are meeting with the same lady, so you have to wait until she's available. So,
Okay, I was doing the right
yeah,
thing. Thank you.
all three of you all have this, are in the same property location, so it's one attorney on that matter.
Okay, thank you.
No problem. And let's see, Mr. Akanicki.
Yes, Your Honor.
Your 9:15 appeared a little early. They're actually in the room with legal services now. Matter set for hearing August 14th at 3:30.
Thank you, Your Honor.
Thank you. You're all set.
So I should be good to, I'm all good to go.
Yep, you're free to disconnect.
Okay, all right, thank you.
And if there is a court officer or clerk in the courtroom, could I be placed in a breakout room with Mr. Wells?
Can you hear me? I can't hear you neither. One second. I can't hear you at all neither.
Madam Clerk or Court Officer, we do have a consent judgment with Mr. Wells. His phone number is still in the breakout room, so the phone number will need to be moved back. And then whenever the judge is available, we have a consent judgment.
Sounds good.
Thank you. Mr. Wells, just hang tight.
Okay, no problem.
Hi, Ms. Sutter.
Good morning.
Good morning. My understanding is you're doing arraignments today?
I am, yes. I've been trying to wrap up intake interviews.
Okay, wonderful. So I just wanted to know if we could do them early because I need to get out of here for an appointment in the afternoon.
I'm available right now if you'd like to do them.
You've met with everyone already?
If you are just talking about the people for LPD, I just finished speaking with the last of them.
Yeah, my understanding is there's only 3. They just sent me the one packet, so I need to get that back. So it'll probably be about 30 minutes.
Okay, very good. I'll log back in about 30 minutes if that's okay.
All right, wonderful. Thank you.
Thanks.
They have one for who? Mr. Wells. Okay, on the record in the matter of Briarcliff Apartments versus Darion Wells, phone number 24-03670, council appearance.
Good morning again, Your Honor. Jen Wilburn, P83143 for the plaintiff.
Okay, Mr. Wells is present via Zoom. Today was the date set for a pre-trial on an eviction matter. However, the parties met and they're going to enter an agreement today.
That's correct, Judge. The terms of that being there's an outstanding rental balance of $4,475.63 plus court costs in the amount of $188.35 for a grand total of $4,663.98. We've extended the writ date slightly beyond what he would get from the next court hearing. We're giving until August 29th to get that balance paid. I did go over MCR 4.201J with Mr. Wells, and there's no money judgment at this time. Additionally, I requested his permission to sign this to submit to the court.
Okay, very good. And Mr. Wells, is what counsel said accurate as to how you want to proceed today?
Yes, it is.
Okay, and so you understand your right to have a attorney represent you in this proceeding?
Yeah.
And you're willing to give that right up today?
Yes, I am.
You also understand your right to proceed to trial. You could demand a jury trial. You
Yes, I
understand
do
that?
understand. Yes,
And
I
if you give
understand.
up, by giving up your right to trial, you'll give up your right to make any defense or any claims as it relates to condition of the property. You understand that?
Yes, I do.
And you want to give up your trial right?
Yep.
Anybody threatening you to give these rights up?
No, ma'am.
So again, you have 3 business days from today. If once you leave here, you realize you misunderstood the proceedings or the rights that you gave up today, you can return to the court and request to have this judgment set aside. You've given counsel permission to sign the agreement on your behalf, correct?
Yes.
Do you have any questions for the court?
Nope, I don't have any questions.
Okay, any additional matters for the record, counsel?
Nope, that'll do it. Thank you, Judge.
Thank you. You're all set, Mr. Wells.
Okay,
Have a good
thank
day,
you.
Your Honor.
Have a good one. Christopher Kelly, you can start your video. I see Morris McDaniel. Mr. Kelly, you can hear me?
Yes.
Okay, so Mr. McDaniel, Mr. Kelly, and then Ms. Mashad, today's the date that's set for a hearing. This is, I'm sorry, a pre-trial. This is an eviction matter. I'm gonna play a video on the screen here. It'll go over your rights and it'll advise you of potential ways that you can resolve this matter and resources that you may be able to access to avoid eviction. We have representatives from legal services if you want to do an intake today to see if they can represent you. They're available for that purpose. And then also our eviction diversion facilitator is present and can meet with you as well to discuss any other resources. And then we'll get you your next court date. That'll be a date set for a hearing, okay?
Okay.
Let's see.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Okay, Mr. Kelly, your matter is scheduled for hearing August 14th at 3:15 in person at the court. Mr. Kelly, did you hear me?
No, I didn't. Can you say it again?
Your matter is scheduled for a hearing. You must appear in person, and that's on August 14th at 3:15.
Okay.
Did you want to meet with legal services today or with the eviction diversion facilitator?
No.
Okay, well then you're free to go. Mr. McDaniel, your matter is scheduled for hearing in person at the court August 14th at 3:30. Did you want to meet with legal services or our eviction diversion facilitator?
If I have that paid before I go, do I have to?
If you're going to pay in full, that includes the court costs, then the plaintiff can't dismiss the matter against you, okay?
How much do they have me for?
Mr. Devlin, can you advise for Mr. McDaniel what his past due amount is?
Yes, Your Honor. Ms. Daniel, I show your balance is exclusive of court costs is $948. And there's 160, sorry, blend it up. 165.04 in costs. So your total is $1,113.04.
Okay, so when I go to court, because one of those fees was supposed to be waived. So if I do go to court, I could talk about that. Because I think I'm supposed to be at like 850 or something like that. And no, I would take what did you ask me, Your Honor? Like the help that I would need.
Well, actually, if you wanted to meet with legal services or with the eviction diversion facilitator, if your intention is to pay the past due and you think that there's just an issue of the ledger, meaning there was something that should have been waived, you could probably work through that prior to that and still pay the balance. If your balance is at zero before your hearing date, then you won't need to appear, but your balance would have to be at 0 before then, okay?
Okay, and when I do come to date, is that for me to leave the premises or make sure I pay the rest of the balance? Because I'm gonna pay most of it tomorrow. And it would have been paid off, but the extra fees I don't know about.
What are you calling extra fees?
Like 200 and something bucks, because I was late on my rent this month, so I should owe $850 something. This something from last month with a lease agreement or something like that. I don't know where this extra money is coming from. It always keep coming up. Like I keep paying extra, and I stay in the hole. I don't know where this money is coming from. And when I go to the office, they can't tell me.
Okay, Mr. Devlin, can you provide a ledger for him?
Sure, Mr. McDaniel, do you have an email address or you want to chat it to me? I don't know. You
I
can
could go to
share
the
it.
office and get it.
Okay.
I'm looking at it still don't make sense. So I probably will have to just wait till my court date or try to figure it out. But I'm trying to pay it. I'm not trying to not pay it. I'm just need to know where the extra money is coming from. I don't have it to just pay.
I understand. If I can briefly try to help you out with that. I understand what you're saying. There was some sort of $300 month-to-month adjustment that was removed on July 1st. I show that you have a credit for that. There's a late fee for July, a late fee for August, then there's some like a water, a trash, a pest control, and some other utilities that are on there. So that's why I'm imagining all your, we'll call it extra fees on top of your rent are probably coming from.
No, I have one question and I'm done, guys. I wasn't late in July. So if my money order shows that I wasn't late, would that late fee be waived? Because they said something about that. The office said I paid on the 9th and I definitely wasn't late. I just got to find my money order receipt. I was looking for it before court. But I have no problem with paying. I would try to have it paid before the 14th. And if I do, the balance will be no more than $200 or $300. And I could take care of that if I have to, if we don't come to a conclusion.
Okay.
So I'm just trying to take care of the situation. I'm not trying to,
I understand.
Okay. So, excuse me, Your Honor. Well, I know you can't give me legal advice, but
yeah, but if you want to meet with legal services, I can put you in a private meeting room and they can do an intake with you.
Okay, thank you. Yes,
Nagel, can I put him in the room with you?
Yes, Your Honor.
I'll add him to room 3. Okay, let's see. Ms. Michaud, your matter is scheduled for hearing August 28th at 2 p.m. in person at the court, okay? Did you want to meet with legal services and or the eviction diversion facilitator?
Probably, because my account is at a 0 balance, so everything is paid, but my problem is why I was charged that. I was charged renter's insurance when I already had renter's insurance, and that caused late fees, legal fees, et cetera, et cetera.
Mr. Devlin, does her account show 0?
I'm sorry, Your Honor. I did not hear the case number.
That was Sierra Michaud 24-03766.
Yes, Your Honor. I had submitted a dismissal for her earlier today. Ms. Michaud, I don't have access to what you're discussing about renter's insurance. I show a credit for a late fee removal in June, but I don't show any other credits. And I'm trying to look. I don't see a forced place insurance.
I have proof right in front of me of that, of insurance through Lemonade, as well as that late fee was removed because they tried to say I wasn't on time, but thankfully I had the office sign and date my copy of my payment, which was the overpayment for the renter's insurance, late fees. I also have each date written down that I was charged renter's insurance, and the late fees provided from that, and why.
Ma'am, I don't
Why it should-
see, insurance on your I pulled your ledger yesterday, and I don't see a forced place insurance on any of it. I show you a zeroing out your balance July and August. I don't show you anything.
I have it right in front of me. There's that, as well as there's a problem that utilities just went up recently. And so
Did you all want to go in a private meeting room, because we're not holding a hearing right now? And I don't know if you all are trying to work
I'm
something
happy
out.
to talk to her, Your Honor. But
Let me put you in a private meeting room with him so you all can discuss that. And then he's already submitted a dismissal. I've not reviewed or signed that dismissal yet. I don't know if you have counterclaims, what it sounds, the potential here. And so you can do one of two things. You can meet with him and try to discuss this. You can meet with legal services and do an intake to see if they can represent you. You can do both. And if you decide that you want to pursue a counterclaim, you would need to file your counterclaim, and then we can continue on that hearing date with your counterclaim, okay?
Great.
How do you want to proceed? Did you want to meet with him, or do you want to meet with legal services first?
I would like to meet with him.
Okay, we'll get you on a device. Do you have a phone with you that you can get on Zoom? If not, we have an iPad.
Yeah, I don't have
Okay,
enough
we'll
storage
get-
space on my phone.
Don't worry, we'll get you on Zoom.
Your Honor, the only other case that I have that was not a dismissal was at Dante Hamilton. Is that set for the 14th at 3:30 as well?
August 28th at 1:30. And so Lipsy was a dismissal?
Yes, Your Honor. I submitted, I believe, 5 dismissals for my 8 cases. Neighbors, Turner, Aldasuki, Lipsy, Wiggins, and Mashad are all dismissals. So I guess that's 6. And then Hamilton and McDaniel and I'm missing the last one.
Okay, wait a minute. I see some at 10:15. You said those were dismissals? Neighbors,
Neighbors dismiss.
Wiggins dismiss,
Yes, Your Honor.
and let's see.
Aldasuki is dismissed as well, Your Honor. That was the one that there was that they had legal aid had filed an appearance. I think she did so out of an abundance of caution. Ms. Hall, I can see her on the Zoom.
They submitted it late, so he was gonna have to reset it.
It's dismissal. Oh,
Yeah.
got it. And then Wiggins was in custody?
Yes.
Got it. Okay, I have that noted, so none of your 10:15s will proceed. Okay. And then we'll get Ms. Mashad on a device.
I believe all the pretrial ones that are going forward have been heard.
Correct.
So that's you said 8:14 at 3:30 for the Mr. Kelly and McDaniel, and then you said Hamilton was 8:28 at 1:30.
That's correct.
Thank you, Your Honor.
Thank you.
Excuse me, Your Honor.
It was for October, for show cause.
They said it was for show cause.
Yeah, but they gave it to me. I don't need to say anything for show cause, because they already did. And then he did it already in October anyways. Let's see. Mr. Devlin, I'm gonna put you in room 4 with Mashad. Mr. McDaniel, well, you were all set, or did you want to meet with the eviction diversion facilitator?
No, I wanted to know the time on April 14th that I had to be in court.
At 3:30.
Okay, thank you very much.
You're welcome. You're all set.
Okay, bye-bye.
Bye.
So pretty much they told me they can do nothing. And I have to get a hold of property management owners, but I've tried that.
Okay, so how would you like to proceed, ma'am? You wanted to, you can go downstairs and file a counterclaim if that's what you want at the civil department.
Probably that.
Okay, that's on the 5th floor. When you get off the elevator, you'll go to your right, go all the way back to the civil help desk and let them know, okay?
Fifth floor?
Yes.
Lyceum?
Yes. Thank you. Can you hear me in the jail?
Yes, Your Honor.
Okay. Okay, on the record, in the matter of the people of the state of Michigan versus Deshaun Alexander, this is file number 24-02302. Council, may I have your appearance, please?
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Alexander for today's arraignment.
Mr. Alexander, can you hear me?
Yes, ma'am.
Okay, today's date and time that's scheduled for an arraignment. I do have a felony complaint here. The complaint alleges that on or about August 7th, 2024, at the area of North Pine at or near Genesee, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of controlled substance delivery, manufacture of cocaine, heroin, or another narcotic, 50 to 449 grams. The allegations are that you did possess with the intent to deliver 50 grams or more, but less than 450 grams of a mixture containing the controlled substance cocaine, and that this is contrary to Michigan Compiled Law 333.74012A3. This is a felony with a maximum penalty of 20 years in prison and or $250,000. A consecutive sentence may be imposed for any other felony conviction. There's an habitual offender fourth offense notice. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about March 31st. 2021. He was convicted of the offense of home invasion in the 3rd degree in violation of MCL 750.11084 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about May 5th, 2016, he was convicted of the offense of delivery, manufacture of narcotic less than 50 grams in violation of MCL 333.74001A4. In violation of in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about May 5th, 2016, he was convicted of the offense of possession of methamphetamine in violation of MCL 333.74032BI in the 30th Circuit Court for Ingham County, State of Michigan. And therefore, the defendant is subject to the penalties provided by MCL 769.12. So that would enhance the penalty in count 1 to life if the primary offense has a penalty of 5 years or more, or 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge and the maximum penalty, including the habitual offender fourth offense notice, which does enhance your maximum penalty to life in prison? Do you understand that?
Yes.
You have the right to be represented by counsel. Ms. Sutter is with you today to represent you for the purposes of your arraignment only. You have the right to be represented by an attorney at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defense office appointed to represent you at the expense of the public. You understand your right to counsel?
Yes, ma'am.
Okay. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you stand mute. If you stand mute, the matter will continue all the way to your jury trial. You have the right in this matter to have a preliminary examination, and you have the right to have the preliminary examination within 21 days of the date that you are arraigned, which is today. That timeline will not change unless you waive the timeline yourself or the court finds good cause to go beyond the 21 days to reset that matter. Your matter is scheduled today for a probable cause conference before Judge Michael Anthony Flores on August 15th, 2024 at 8:30 in the morning. You have a preliminary examination before Judge Flores, August 22nd, 2024 at 8:30 in the morning. You can appear in person or you must appear in person for your preliminary examination. You may appear via Zoom for your probable cause conference, okay?
Okay.
Okay. You have the right, again, at the time of your preliminary examination, to require the prosecution put on proofs that would establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. If this matter proceeds beyond the preliminary examination stage, the matter will can be bound over to the circuit court, where you'll continue to trial. You have the right to a jury trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to require the prosecution prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any of the witnesses that they intend to call against you at your trial. You can present evidence or testimony on your own behalf at trial if you'd like, by waiving your right to silence. You also have the right to call witnesses or present evidence through subpoena at the time of your trial. And you also have the right to have them prove each element beyond a reasonable doubt. Do you have any questions about those rights?
No, no, ma'am.
You have the right to be considered for pretrial release from custody. We'll address your bond in a moment. Counsel, is he requesting court-appointed counsel?
He is, Your Honor.
Okay, the court will note that he's requesting court-appointed counsel. The court will enter a plea of not guilty on the defendant's behalf. Let's see. What is your address, Mr. Alexander?
810 Conrad Ave, Lansing, Michigan, 48911.
Are you currently employed?
Yes,
Where?
I'm a barber.
Say that again?
I'm a barber.
Okay, you're a barber?
Yes.
What's your phone number?
517-885-0777.
Are you currently on probation or parole?
Oh, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. I did have a conversation with Mr. Alexander this morning, where he did advise me he's living and working in the Lansing area. He was able to provide a Lansing address to the court today, and he is employed full-time, as he said, as a barber in the Lansing area, where he's been for quite some time. He did also advise me he does not recall any prior failures to appear in court, and while there is some criminal history here, I don't believe in this matter that he is a danger to himself or anyone else, and with the appropriate bond conditions, I don't believe he's a flight risk in this matter. He also does care for 3 children in his home, and he's quite anxious to get back to them. I would respectfully request the court consider a personal recognizance release for Mr. Alexander today. Thank you.
I do have a bond report from Ingham County Pretrial Services that is consistent with your argument as to the history of appearance in court. Does not have any qualifying failure to appears, and this is not, he does have a lengthy criminal history, but the court does not see that there is a risk of danger or harm to the public at this time. Personal recognizance bond will be granted. Bond will be set in the amount of 20,000 personal recognizance with the following conditions. While out on bond, you're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to travel outside the state without prior approval from the court. Not to possess a firearm or any other dangerous weapon. You need to report to all of your court dates. And you also need to make report to pretrial services within 48 hours of your release from custody. Do you have any questions, sir?
No, ma'am.
Additional matters for the record, counsel.
Nothing further. Thank you.
You're all set, sir.
Thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Mario Lovelace, file number is 18-05288. Counsel appearance.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Lovelace for today's bench warrant arraignment.
Yes.
Okay, Mr. Lovelace, it looks like you've been in warrant status since September 10th, 2020. Looks like were previously arraigned on an uttering and publishing allegedly having occurred back on January 2nd, 2018 at the address of 3022 South Martin Luther King Boulevard, City of Lansing, Ingham County. Allegations again that you did utter and publish as true a certain false, forged, altered, or counterfeit record, instruction, or other writing with the intent to injure or defraud, knowing said instrument to be false, altered, or forged, or counterfeit. Said instrument more fully described as follows. It was allegedly a check with the date of December 29th, 2017, the amount of $379.63. Drawn on JP Morgan Chase Bank, payee being Mario Lovelace, in the drawer purportedly to be WT Mac LLC. That is a felony. The maximum penalty was 14 years in prison. You were arraigned, you were given a 5,000 personal recognizance bond. You had a probable cause conference date of September 4th, 2020 at 11 o'clock in the morning via Zoom. You were assigned a public defender, Jared Austin, who had been in contact or attempted to make contact, and you failed to appear for your probable cause conference, but your attorney did represent to the judge who handles your matter, which is Judge Stacia Buchanan, that he had spoken with you and that they were expecting to continue to your exam, which was set on September 10th. September 10th came and September 10th, 2020 came and passed and you did not appear. What happened?
I stay all the way in Flint, Michigan. I ain't have a ride then.
You expect me to believe for 4 years that you didn't have a ride to court on a felony?
Yeah, I have forgot.
Okay, sounds good. Counsel, you can address bonds.
Thank you, Your Honor. I did have a conversation with Mr. Lovelace. I also reviewed Mr. Austin's notes here, and I see much of what the court has indicated. He was in contact with Mr. Lovelace via phone calls through the probable cause conference, and then been advised his client was struggling to find transportation to Lansing for the preliminary examination. That was also the discussion I had with Mr. Lovelace this morning regarding his non-appearance that day. I understand certainly the concern of the court here regarding a missed court date, especially with such a gap in time here between that and his now appearance before the court. He did advise me that he is still living in the Flint area. He does have some family and friends there. He's hopeful may be able to assist him with transportation now. He was able to provide a contact address for us as well as contact information for his attorney to reach out to him. If it's within the discretion of the court here, I would ask the court to consider some kind of a cash or surety bond for him to attempt release here so that he can seek employment and continue working with Mr. Austin on this case. Thank you.
What's your address, sir?
At 1006 Adams Avenue.
What's your phone number?
I don't have no phone number right now. I'm using my mama phone.
What's her number?
810-336-1265.
It's the same exact information you gave in 2020. So it doesn't sound like your situation has changed. You still live in the same address. You still don't have a phone. You use your mom's phone, which is the number that you gave at the time of your arraignment, August 27, 2020. And you still don't have your own transportation. So the court believes that the likelihood of his returning to court for his next preliminary exam date, which is August 22nd at 8:30, is very, very low because nothing has changed since the last time, because he told me he didn't have a way for 4 years to get here. Ironically, he was picked up in Lansing, so he must have had a way to get here. But he didn't want to prioritize court. So what we'll do is we'll set his bond in the amount of $15,000 cash surety. And maybe that will ensure his appearance in court. Do you have any questions, sir?
No.
Your previous bond conditions, which was that you were not to travel outside the state without prior approval of the court, and not to use drugs or alcohol, and to report to pretrial services, those will all continue on that file.
All right.
Yeah, I'm not done because it looks like you have another uttering and publishing 18-04961. That matter as well will be scheduled for preliminary examination August 22nd, 2024 at 8:30 in person at the court. You were arraigned on that one as well back on August 27th. You gave, again, the same exact contact information. The notes in the file are absolutely identical to the previous file. The only difference is the complaint alleging that on or about April 5th, 2018 at the area of 428 South Washington Square, that you did allegedly utter and publish a false, forged, altered, counterfeit record, instrument, or writing with the intent to injure or defraud, knowing said instrument to be false, altered, forged, or counterfeit, the instrument being a check with the date of March 30th, 2018 in the amount of $156.84, JP Morgan Chase, payee being a Mario Lovelace, the drawer or marker being Access in Motion and endorsed by Mario Lovelace. Again, maximum penalty on that is 14 years in prison. Bond will be set at 15,000 cash or surety in that file as well. Unless you have questions for the court, you're all set, sir.
All right.
Thank you.
Thank you. All right.
On the record in the matter of the people of the state of Michigan versus Christopher Pumphrey, file number 23-01079 FY. Actually,
Yes, Your Honor.
just give me just a moment.